Department of Social Development is saying one of the officials that will be dealing with parenting plans. I've got some colleagues over here that will assist with parenting plans. So if any of you need to draft the parenting plans, we will have people on board that will be able to assist you. Okay. But we start 8:30 on the dot. We've got a jam-packed program, so to make sure that we get ultimate out of it. We'll start 8:30 and we will hopefully finish by 2 o'clock this afternoon with everything that we want to do.
Making a version. I mean, it's like Aisha. She's got all the stuff online watching. And then she messaged me, she said, oh, I don't know if I should come or not. I said, okay. I could run the science issues. I said, it's a choice. Just put myself on my bed and drinking coffee. And I can do that and watch. Do you understand?
Thank you so much. Good morning, guys. Good morning, everybody inside. Fantastic. We're still waiting for a couple of people arriving from Sunset West Court. See, Oatsworth Court is here already. Fantastic. And we do see a lot of familiar faces and a warm welcome to people attending online. There's quite a number of people that is joining us virtually. Very welcome to the third of the NPA Community Dialogues. We offer this as an educational forum for people and for like-minded people like yourselves. It's not necessarily public. The people that attend here are mostly attorneys. There's people from the legal aid clinic. There's people from the mediation realm. There's maintenance officers. There are loads of people. So there's a wide spectrum of people attending. And this is the aim thereof. We are very fortunate to use this venue. And we thank Advocate Leon Reiters for organising the venue and for also facilitating this whole process where we can educate and learn from one another. I don't profess that I know everything about maintenance. I surely don't. So does Advocate Reiters. He works with it every day, so but we do not know everything, and we learn and we teach and we get to engage with people so that we can learn from one another. So just on short, there will be opportunity for questions right at the end. We would request you to just jot down your question, just hand me the piece of paper, and then we can address that later on, so that you do not interrupt the presenters. There's quite a number of presenters today. We will have Mrs. Catherine Gray. She will talk a little bit about mediation. We have the Office of the Master attending. We've got people talking about parenting plans. I'll be talking about increases in maintenance. Dion will be talking about opposing maintenance, increases in maintenance. So that should be quite an interesting debate. But if there's any questions or any other comments that you would like to have, please contact us during the breaks if you want to get involved and to chat and just have a question. Pop in and just chat to one of us. Felicity will also be doing a piece on interpretation of the Maintenance Act. Felicity is an activist. She'll be introduced now by Dion. So yes, it should be a quite interesting lineup. Thanks, guys, for attending. I'll speak to you later. I'm going to hand over to Advocate Reiters now, just to do some formal introductions for the people that don't know each other, and a short thank you, and then we'll continue. Thank you.
Thank you and welcome to the NPA DPP building. I'm glad there's such a lot of people over here and such a lot of people online, but I would like to just first and foremost introduce people that are over here. And I know that you are offering your Saturday to be here, and that's already a big sacrifice for you. And I know that some of you have a question that you want answered. And sometimes you can't get to me or to Eugene or any of the people over here. That's the reason why I'm introducing the other people that are over here. And I'm also not doing that to in any way intimidate people, but I found, and we got one email a few weeks ago where somebody said that she felt she couldn't ask a question because of all the attorneys and magistrates and people that were sitting here. And I really don't want that to be the aim of us getting them together over here. The aim of this and the reason why we are offering our Saturdays is for us to educate one another, for us to be able to cross-pollinate one another, because as Eugene just said now, we don't know everything. I'm the one that will say it first or second after Eugene already said it now. that I don't know everything, and I learn every single day that I deal with maintenance, and I actually deal with it every single day. And you'll be here when I start speaking about sections or subsections. And I don't do that to intimidate people, it's just that's the way I've been training people the last few months that I've been dealing with maintenance training all over South Africa. I've been last night in Pretoria, the week before that in Durban, the week before that in Bloemfontein. I've been on the road the whole time. And the reason why I'm saying that is because I want to say a special thank you to Mr. Eugene Opperman. This man is actually leading the process, not me. I'm just providing this video. That's all I'm doing. Everything that you see over here, all of these PowerPoint presentations, all of these communications with you and emails that has been sending out is the work of this man, as well as Martin Oliver, his partner, and the two of them are actually leading the process, not me. I'm just standing over here and have everything done for me. Yesterday, I spoke in Pretoria, and my other colleagues in the other 9 provinces said, but yeah, how are they going to somehow duplicate what we are doing? Because there's a lot of people asking online, when are we coming to those provinces? And unfortunately, we can't get to all the provinces, and that's why last month we had 279 people online, and hopefully we'll have even more today. So that is how big the need is, but we can't get to everyone, and we would love to get to everyone. So how are we going to do this? I'm not so sure, but there are 9 senior maintenance prosecutors all over South Africa that would like to replicate what we are doing in the Western Cape. But while it's not there, Eugene managed to set up an online site so that everything can be streamed via StreamYard for all of us to be able to be part of it. So the introductions I want to do first and foremost is the founder of Child Maintenance Difficulties in South Africa, Ms. Felicity East. She will do another of a series of presentations on financial abuse. I will hand over to her afterwards, after I've done all the introductions. Felicity, can you just stand? Everybody knows you, but just for the see who the beautiful lady is. This is Ms. Felicity East, and she's the founder of Child Maintenance Difficulties South Africa. I keep on saying the wrong number, so I'm not going to say how many. It's just more than 60,000. That's all I know.
73.
You see, so I'm not going to mention how many. Eugene also has a Facebook group with more than 60,000. I'm going to be corrected, but all right, 60 plus, 60,000 plus.
47.
On their group. So that's the number of people that can benefit, hopefully, from the information that we are sharing over here. I know there's a lot of others that have shown interest in wanting to present some of the information and then inculcate this information into their other groups, like the Athlone Community Center and the police forum over there that would love to get involved. So if there are others that would like to come and present their session and say what they are doing and how they can somehow take this message further, whether it is mediation or whether it is the advice officers. I spoke to some of our colleagues that we would love to do this also at advice officers. That good news for the advice officers. I got funding from our national office that we will be able to have flash drives available and parenting facilities available to have a manual that we can have at advice officers dealing with maintenance and dealing with some of the issues involving child matters or children's court matters. And that's how we would like to assist the advice officers and empower them to be able to take it further. Eugene and I will be available to assist with me. We've got a heavy program for April, so I told the advice officers, delegates, that hopefully we'll be able to get to them in May. I just want to quickly introduce some of my colleagues. First and foremost, Marissa Engelbert. She is an advocate. Marissa, can you please stand? I want you to see how beautiful you are. This is my colleagues. That's why I come to work every day and I don't stay out of work, because I'm every day. That's not being sexist or feminist. It's just that this is what I come and stay at every day. So we will stay out of work. If you check my record, I've never been, even during COVID couldn't stop me. I need because this is what I have to do every morning. And it's wonderful colleagues that I work with, people that know their work, that goes for life imprisonment. She just had another life imprisonment in a matter that she dealt with in the High Court over here, and a woman that really knows this stuff, Marissa Engelberg. Blanche, can you put this down, please? This is Blanche Jacobs. She came all the way from Oudtshoorn, so please, if you can't get to me, there is another professional and an expert in the field of maintenance. She drove last night from Oudtshoorn to be here. Next to her, my colleague, Mr. Solomon Michael, can you stand please? Next to Michael, or next to Blanche, is Mr. Mantenkosi Daus. He is the maintenance investigator in Oudtshoorn. They cover the whole Oudtshoorn Prince Albert area. That's their area. So if you have any information, you can't get to me. Those individuals sitting over there are experts in the field. There will be others coming from Somerset West. Ms. Alison Wapelo and her home team, they're busy rounding everyone up from Somerset West, so they are still on their way. So they will join us soon, and I will introduce you to them. So please, if you can't get to speak to me, at least speak to Blanche, Mr. Daus, or to Mr. Solomon Michael, and they will be able to at least guide you and take down, colleagues, if you can help, just take down the people's details so that we can at least speak to them, or I can make contact with them within the next week or two. Renee, can you just, oh, she's already standing. I want to say a special thank you to Renee Farrakhan, as well as her son, the beautiful young man over there in the back. He's going to take some photos and video footage for us that we can publish on our website. So we've got a full house of people that wants to get involved and is involved in some way or the other in the field of child justice, maintenance, dealing with family court matters, and all of those things that we deal with in our society. And that's why I would like to say a special welcome to each and every one of you that offered up your Saturdays to be here. And I know how much of a sacrifice it is, especially for the number of ladies that are sitting here, having to leave your children, having to leave your family, and offer up not cleaning the house this morning. We just said, to be here. So thank you so much for your time. I really appreciate each and every one of you coming, and it shows how much you are committed to changing and bringing about a change in our society. Mr. Lloyd Frankenstein, you mind standing? Another person of stature. He was a magistrate, and he's got his own organization dealing with mediation. So hopefully Mr. Frankenstein can also be approached for mediation matters in case you need to get some assistance with Catherine over here in front. So these are all people from different backgrounds willing to assist, and whenever they are out there to assist, then please make sure that you make use of them. I don't want to do any other introductions. Eugene and I will do a recap of the other sessions that we started in December during 16 days of activism, then January. The first sessions that we had in the maintenance community dialogue series. So hopefully by then we will be able to take it from there. There's some advocates sitting over here that offered up the time. Please share your business cards with one another, and let's cross-pollinate one another with all the information that we'll be sharing over here. There's information or a handout that we will make sure that everyone gets whenever they come to our sessions. There will be a handout that you can use. Except for that, we will have it electronically available on the website www.childmaintenance.org.za. You will get the handout over there that you can then distribute to any of the other people that couldn't make it today, and the ones that are online will be able to do so. Mr. V. Masiguku, all the way from Pinetown, I know that you're online. as well as all my other colleagues from national office that are online. I want to say a special welcome to all of you. This is how Western Cape is doing it, so hopefully the rest of the country will join us soon. But I will firstly give over to my colleague and dear friend, Ms. Felicity Geest, that will do the first presentation on financial abuse and video. I'm not sure. Okay. Oh, sorry. I forgot. Ms. Catherine Gray will be first. Thank you so much for. Is the presentation? Okay. Catherine's watching. Ms. Catherine Gray, I'll hand over to you. Thank you.
Thank you. Good morning, everyone. I did push my way in earlier, so it's not Dion's fault. My husband is turning 60, so we have a family celebration later. So I have to leave a little bit early, but Natalie will be here during the whole day, and she will be able to answer any further questions. So just quickly, my name is actually Catherine Coetzee, but I practice under the name of Catherine Gray. And I've been doing that for the last 20 odd years, close to 25 now, as a family law divorce attorney in the Eastern Cape in East London. And my practice still continues to run, but I have moved down to the Western Cape. And because my reputation does not precede me here as being the go-to divorce lawyer, I decided to do what I really, really passionately believe in. And what I really do believe works, and that is mediation. Even in the divorce litigious field, 99% of divorces are settled on the steps of the court after the parties have been depleted of cash resources, substantial animosity, fights, they've destroyed any possible relationship that there could be. And that is when they don't want to step into the, and that is when they don't want to step onto the platform and give evidence and air their dirty laundry. So I've established a company in Somerset West in the Western Cape. It's called Mediations Matter. I like to say that that's the platform where communication matters. Mediate, don't litigate. If people see me in East London, they'll go, "Rich, coming from you," but I really do believe that this is the platform. Now, I can imagine people sitting here going, how am I supposed to even speak to this person and mediate with him or her when we can't even communicate? There's no ways I'm going to sit and speak to him. And I can almost guarantee you that every matter, every dispute, no matter how the parties feel about each other, can be mediated. And towards the end of the slideshow, I'll actually show you a message that Natalie received yesterday after a mediation session. And I'll give you a little bit of background on that. So, just quickly, what is mediation? Mediation is a platform where parties in a dispute voluntarily agree to sit down and try and resolve their dispute. So what is the purpose of the mediator is not to get involved in the dispute, but during the process to facilitate the parties in the dispute. Almost a buffer, for want of a better word. So the mediator's job is not to say, do this or agree to that or don't agree to this. The mediator's job is to say, well, let's explore this idea of what this person wants. So let's explore that idea to create a platform where you can explore various ideas. And the great thing about mediation is that it is confidential. So whatever we say in mediation, if I say, I offer you my car, and you go, no, I want your boat. You can't turn around later and say, but you offered me the car. confidential, which makes it a platform where people can explore any possible thing without being prejudiced later. Okay. If you're going to litigate, I think 12 to 36 months is maybe conservative, especially in the Western Cape. In the Eastern Cape, it would be applicable. I think in the Western Cape, you're looking at 5 years, Eugene, if it's a complex litigation matter, by the time you get to trial. And mediation it can take anything from 1 to 3 days. If it's a really complex matter, it could take much longer. And then also the cost of mediation versus litigation, it's a no-brainer. Now, I appreciate that maintenance, quite often people engage attorneys in maintenance. In East London, I just refuse to do maintenance personally because we can't justify the costs to my client. So we've kind of developed a process in our firm in East London where we facilitate the client. So we will assist them. I'll train my candidates to assist them to complete the course or to assist them to prepare for court. But when someone's claiming maintenance and they have to employ an attorney, it's absurd. And when someone claims they can't afford maintenance, but they come to court with an attorney, it's absurd. I mean, you look at this and you go, okay, you can't afford maintenance. Why would you want to pay someone to tell me you can't pay me? It doesn't, it doesn't make sense, but it is what it is. And obviously, in the maintenance, I mean, we say 5 to 15 appearances. It could be more. I mean, we know you get to court, and the reality is that our system cannot maintain the volumes. It's no hidden secret. I don't believe that every maintenance officer is useless and lazy. They just can't work. They just can't get to work. And I think when you are working under that pressure, that constant pressure of, I'm never going to get to it. Some people do just give up and go, whether I do or don't, it's not going to make a difference. So we're working with people who are under severe pressure, under severe stress to try and get the job done. And unfortunately, the public out there suffer. In mediation, you control the process. So you can say, I'm invested in this process. I'm going to give it 3 or 4 sessions and see where we get. And if you have a mediator who can manage the session and almost like dust off issues that we shouldn't be dealing with now, we'll deal with them later. Let's not deal with that now. Let's not deal with the children or what makes us angry. Let's just focus back on what we're dealing with now. It works like a charm, and people actually get to agree. It's amazing. If you are going to go to court, your days off work are for every appearance. Again, mediation, you can plan it. You can say it's not going to take 10 hours or 5 hours or a whole day in court. Mediation session should not last longer than 90 minutes because people can't focus and give their attention to something for an extended period of time, and then they get tired and start arguing. And then obviously the stress that's related to litigation, which is your maintenance matters, included in that, and the stress that is involved in mediation is so different. One question that you need to ask yourself is, or that maybe an answer that I should give is, if I can't afford to feed my children, how do I afford mediation? Because I can go to the maintenance court for free. Yes, mediation will cost you, but the time, different mediations, different disputes are charged differently. And so what we do in mediations matters is we use Natalie to mediate maintenance because she can charge a much lower rate, and so it's affordable. So, and both parties contribute towards the maintenance, so the mediation. So her rates are, for a mediation, say we're going to mediate for an hour, it's 500 Rand. Then each party must pay the 250 towards that 1 hour session. So it's both parties are invested in the outcome because they are paying, but it is still an affordable alternative than to go into the maintenance court. How are we going to maintenance and Section 6 and Section 10 inquiries? In fact, mediation, in inverted commas, actually almost takes place during these inquiries, because what is the maintenance officer asked to do? He's asked to find out from the applicant how much do you need, and he's asked to find out from the respondent how much can you pay. But he's not trained as a mediator. Secondly, he doesn't have time to mediate. He doesn't have time to investigate and to discuss with the parties. Come on, let's really unpack this and see where we are. So what do? You want X, you want Y, no, we can't, and so we're going to take the next step. And that is essentially my experience that happens in these Section 6 and 10 inquiries. I do feel that at this stage, the maintenance officers or whatever should, at this stage, have a platform where they can refer the parties to mediation. And I think it would be a long shot to ask whether there would be funding for this or not. But, but I do think it is something that the department should seriously investigate, taking a lot of pressure off not only the maintenance officers and the system, but if you can mediate a large percentage of your maintenance disputes, it would go a long way and prevent future maintenance disputes coming back. And then I just want to end off with this. I know the time is short, and I don't want to waste enough time, too much time, but this is a message that someone sent Natalie yesterday after a mediation. And just a little bit of background to this. Natalie was we were contacted by the husband, the ex-husband, to mediate a divorce, a maintenance dispute. The ex wanted to increase the maintenance and he wanted to decrease the maintenance. So we think his initial approach was, I'm going to ask for mediation, I know she's going to refuse, and then I'm going to get a certificate to say it can't be mediated. Because if I recall correctly, in the divorce settlement agreement, adjudication was referred to. So it took Natalie, and I take my hat off to her, a month to get these parties to agree to mediate. There is so much animosity between these two people that they have blocked each other on WhatsApp. They do not communicate. They've got 2 little children. They don't even, let's drop off at the gate scenario. It's terrible. And she did not want to mediate. She said she doesn't want to sit next to him. She can't stand him. And we had them sitting next to each other at a table which was not big enough for them to avoid each other, but big enough not to be able to strike out at each other. And after the mediation, she is so grateful, and they're coming back for a second session. In the first session, it lasted 90 minutes, and we agreed on the costs of the children. We only dealt with, let's try and see if we can agree what the children cost. Let's not say who's going to pay what. We'll deal with that later. But at least now, they walk out and they're like, okay. And they were making arrangements to drop and collect outside, and we sort of just let it be. But people say, it will never work. It won't work if you don't try. So on that note, I want to say thank you for the time. Next time I'll maybe be able to share a little bit more information, or if anyone wants to. These are our mediators. It's myself, Natalie, and Johan Vesta. He's also joined us. We are open to further mediators joining our platform if they so wish. We're trying to create a company where certain mediators can be represented in various areas, different languages. We want to create a platform of mediators that can suit everyone's needs and pockets. I obviously mediate more complex divorce, maintenance issues, commercial mediation, and then I love this saying, an ounce of mediation is worth a pound of arbitration and a ton of litigation. Thank you, folks, for your time. I really appreciate it. Are there any questions? Unfortunately, I have to leave. My husband already raised his eyebrow when I had to come today, and I had to bring my son as a chauffeur because I can't drive. So, are there any questions? Yes.
I would just like to ask you to come back. If you could do something about the conversion of a parenting plan into a maintenance order, because there seems to be a lot of confusion about what to do and how to make a parenting plan into a maintenance agreement and how you can enforce the parenting plan that deals with maintenance in the maintenance court.
Okay, so just off the bat, and this isn't really mediation related, can I answer this quickly?
Yes, sure you can.
So a parenting plan is an agreement between the parents on how we will deal with the children. And quite often, and quite often, my voice is so loud, I don't often need a speaker. And quite often, attorneys or the drafters of the parenting plan will include provisions in the parenting plan relating to maintenance. And it depends at what stage a parenting plan is drafted. But so when I deal with divorce matters, I will do my settlement agreement, and the settlement agreement will contain everything pertaining to the divorce. And I like to include my maintenance provisions in my settlement agreement. Some people include it in the parenting plan. Now, that parenting plan on its own, as a document unrelated to maybe a settlement agreement or a children's court application, can't really be made a maintenance order or a court order. Although you could probably take that parenting plan to the children's court and have it made a court order. Whatever is then in that parenting plan is ordered by the court, and if it contains maintenance provisions, those will be enforceable as maintenance. So when you say converting a parenting plan to a maintenance order, it depends on what led to that parenting plan. If we just have two parents disputing, and they then enter into an agreement with the parenting plan, one should make provision in that parenting plan that either party can approach any court with jurisdiction to enforce the provisions of the parenting plan, or to make the provisions of the parenting plan a court order. That would then, in effect, mean that any provisions relating to maintenance would then similarly be a court order.
Thank you for that. That was quite insightful. We will definitely follow up with mediation questions pertaining to your parenting plan. That will be discussed a little bit later when the people from the parenting plans will give a full presentation, and then then we can just elaborate on that. Yes, mediation sure does have its value in maintenance, not so much in maintenance courts itself, because it is a system governed by officials from the DOJ. But most certainly when a client comes to you and they are busy with a hearing divorce, then surely, yes, you could utilize your mediation skills for them. I use it quite often in my practice. I give them the opportunity to hit each other and to mop up the blood afterwards, vent, bitch, moan, scream, and then I say, all right, that's fine. And what I usually do is I take two photos of the children, if there's two children. And I ask them, that's one of my prerequisites. I take the photos of the two children and I put it on the table. Now we're sitting around the table, and then once they started bitching and moaning and the emotions get flared up, I would just withdraw and I would just sit back and stare at the photos. And then once they quiet down, I'll count in my head for 60 seconds, and believe me, it's the longest 60 seconds. And then I would ask you, are you finished now? Can we continue? Because we're all in it here for the benefit of the child. That seems to work for you. But that's on mediation. Next up, we'll have Felicity having her slideshow, and then you and I will continue with the more legal stuff on that side. Let me just get your slideshow ready. The video as well. So, she is going to start off with showing a video, which will be live streamed as well. And then afterwards, I'll start your slideshow for you. It's just a short video.
Alright, and this is happening in a situation where we also have the Employment Equity Act in our country that is promoting them that gender equity, you know, at the employment space, alright? So we as women need to move from,
This is happening in a situation where we also have the Employment Equity Act in our country that is promoting then that gender equity, you know, that culture that is promoting, you know, that men, you are actually the male dominance in every sector, all right? So now coming into our courts, all right, I'm getting this question and I'm quite shocked, all right, that says that even, I'm not sure whether it says that women at our court were saying that, no, go and take contraceptives, or is it a social construct that we have? But it's to say that the legislation is actually permitting that woman, even the woman herself, to be maintained by the husband, depending then on the financial circumstances of the two parties, all right? And this is also a matter that is also even promoted in relationships that are experiencing violence, that is the domestic relationships that are experiencing violence. If you go and make an application for a protection order, all right, and it has a provision there that says that then if you have children, or if you as well, you need your partner then to support you financially, there is an order that can be made, all right, for you, you know, to be supported by your spouse, all right? And until such time, then the maintenance court issues a maintenance order, all right, against the same respondent, all right? So then we need then to look at how we are socializing our children, how we are, you know, the values that we have in our families and so on, because these are the values then that you see them now being important then at the court environment, because that magistrate who is issuing that order, we do not know what is in the mind of that person. We have the law that is written in black and white, but then the problem is with the implementation of that particular law, because the law does not implement itself, it's implemented by people. So then if you have a person then who is a judicial officer who has a patriarchal attitudes and belief systems, you will see that also in the decision and the judgments that are coming out of that person, all right? So we have that challenge, all right, of you cannot let a person to leave your attitudes at home, all right? So that is why you find that at our service points, at our courts, we find the people, you know, are experiencing secondary traumatization, secondary victimization, despite the training that is being provided. It is because of the fact that the attitudes that are in the home environment where the poison is, all right? Because it is the home that is a breeding space of patriarchy, all right? And then that gets then to other sectors of life where people then are found themselves at the working spaces, all right? So that's what I want to say in this area. Thank you.
this justice system is just a theory. I want to pull my hair out when somebody talks about just how progressive our constitution is and how it makes things better. That's the most depressing constitution, because you had apartheid and you had, the ANC against each other. The ANC did not want to see in the constitution what the apartheid system used against them in the law. So they made certain things go away, and we will forever pay for that as women. And the fact that men do not pay maintenance because of equity and equality. But Malumba Fana said it so well, that when women bring in so much, I'm already taking care of this child. When the child is sick, I go and sit at Tembisa Hospital the whole day. I make sure this child goes to school. The only thing I remember in my own case, my partner, who has not even paid 1 cent, told me, Bona, I'm going to say I can only afford 250. And I did not want to take myself through that embarrassment. I struggled with my daughter, but it's because the system allowed. We are the worst in the world. South Africa is disgusting. Gender-based violence because of men. The fatherless children, it's up to 72% of children do not know or live with their father in the house. It is a disaster, and we cannot continue to be okay with it. How do we fix it? In America, you don't pay maintenance, Paulata. They don't care if you are Puff Daddy or you are who, or you are Kanye West. They will fetch you. When we talk about 50-50%, 50-50, what do we mean? How do we install that? But yeah, we have a lot to unpack, Fina, but I just don't want it to be a talk. I want it to go to the justice system. When you talk about transform the justice system, we don't just talking about getting rid of men, getting rid of white judges. We're talking about getting rid of these patriarchal princesses who also speak about, I remember there was a judge who said, rape is part of our culture, our rite of passage as black girls, that we will be raped by our fathers. And this person was practicing. It is disgusting. We need to do something very real about this system called patriarchy.
I raised the question about how patriarchy has actually captured the maintenance courts for the benefit of men. And the first speaker was actually from the Department of Justice. And her first response, which was missing of the video, was that the Maintenance Act is not gendered. It's neutral. And even men can claim maintenance. So, like, I'm going, like, what the hell? You're a patriarchal princess, because immediately you made it about men. You neutralized women's struggles and you made it about men. And we see this in the space. How do you shut women up? Neutralize it and make it about men. The thing is, the law might be neutral, but it has a very gendered impact. Decisions have short and long-term impacts. Whilst the Maintenance Act is not gendered, it is a disproportionate gendered representation and impact. While it is human nature to be biased, it is not constitutional to impose one's bias onto others in matters pertaining to constitutional rights and in the best interest of the child. The narrative of lack of resources and training has to cease. Incompetency is compounding the suffering, poverty, and gendered violence experienced in the majority by women. Bias and prejudice has to be eliminated from the interpretation, application, and enforcement of children's fundamental human right to life, to child support so that they can reach their full potential. The preamble of the Maintenance Act 99 of 1998, to establish a society based on democratic values, social and economic justice, equality, and fundamental human rights. Then it goes on to say, by the establishment of a fair and equitable maintenance system, and whereas the Republic of South Africa is committed to give high priority to the rights of children. As committed to in the Declaration on the Survival, Protection and Development agreed to at New York on the 30th of September 1990, and its accession on the 16th of June 1995 to the Convention on the Rights of the Child, signed in New York on the 20th of November 1998. Article 27 of said convention specifically requires the recognition of the right of every child to a standard of living which is adequate for the child's physical, mental, spiritual, moral, and social development, and to take all appropriate measures in order to secure the recovery of maintenance for the child. Then we have the following. And whereas the recovery of maintenance in South Africa possibly falls short of the Republic's international obligations in terms of said convention, and whereas the South African Law Commission is investigating, in addition to the recovery of maintenance for children, the reform of the entire South African maintenance system. In the last paragraph it says, emphasizing the importance of a sensitive and fair approach to the determination and recovery of maintenance. So within all of that, it sounds like pretty awesome, doesn't it? But if, from our lived experience, is any of that a reality in the courts? And this is how the Maintenance Act starts. The Act shall not be interpreted so as to derogate from the law relating to the liability of parents to maintain other persons. Just about every single woman's experience is, there is an excuse. As to why it cannot be finalized, as to why the child's real needs cannot be met. So it all goes away from what the law is being developed for. So there's certain basics that have profound impact. And obviously, it's the contribution. Section 53A2, that the parents' respective shares of such obligation are apportioned between them according to their respective needs. Any amount so determined shall be such amount as the maintenance court may consider fair in all the circumstances of the case. Undue hardship may be suffered as a result of the postponement. So the standard, almost emphatic reply to questions on both mine and Eugene's group is, it's 50-50. And that is, who told you that? The maintenance officer. Well, that's not what the law says. Well, the maintenance officer didn't give me a choice. He said it's 50-50. It's clear here. How is the interpretation then that it's 50-50 when it says very clearly here it is apportioned between them according to their respective needs? Where does the 50-50 come from? Complaints relating to maintenance. Section 6, 1B, that good cause exists for the substitution. Good cause. So the ones that I've highlighted are the ones that are open to interpretation. After investigating the complaint, the maintenance officer may institute an inquiry with a view to inquiring into the provisions of the maintenance for the person so to be maintained. In order to investigate any complaint relating to maintenance, a maintenance officer may obtain statements, gather information required, a maintenance investigator of the maintenance board concerned to perform such other functions as may be necessary or expedient to achieve the objectives of the Act. It's important to understand why applicants experience what they do at the court. Because you come to a workshop like this and you get informed and you get armed with all the knowledge, and you go there and you are quite confident in insisting that certain procedures and processes take place. And what happens? May. What is good cause? And this is from the lens of interpretation. Section 10(6)(a). A maintenance court shall conclude maintenance inquiries as speedily as possible and shall ensure that postponements are limited in number and in duration. A maintenance court may, where a maintenance order has not been made and a postponement of the inquiry is necessary, and if the court is satisfied that there are sufficient grounds prior to such postponements indicating that one of the parties is legally liable to maintain, undue hardship may be suffered as a result of the postponement. Again, what is as speedily as possible? Who determines what speedy is? For the hare and the tortoise, they're two very different things. What constitutes maintenance? The duty extends to such support as a child reasonably requires for his or her proper living and upbringing, and includes the provisions of food, clothing, accommodation, medical care, and education. So often applicants are told the Maintenance Act says only food, clothing, accommodation, medical care, and education. It doesn't talk about horse riding and swimming and any kind of extramural or extra lessons, extra math lessons. It's a shame they failed because they're just not good at maths. So no, you got to sort that out. And if you want that, you need to pay for that because we only cover the 5 basics. Or they would say, no, sorry, he's only going to pay for school fees. When it's pretty clear in the Act, and it says includes, but that seems to be overlooked. It doesn't say only. These are such basic parts or sections of the Maintenance Act that have profound impact on trying to protect a child so that it can reach its full potential. Age of maintenance beneficiaries and gestation claims. Section 16(1)(a)(2), make an order against such a person if the other person is a child of such sum of money together with any interest thereon, as the mother is in the opinion of the maintenance court entitled to recover from such a person in respect of expenses incurred by the mother in connection with the birth of the child and of expenditure incurred by the mother in connection with the maintenance of the child from the date of the child's birth to the date of the inquiry. Do I need to say more on that? But I'm going to, because people are told that they cannot claim retrospectively. I'm not a lawyer, and I'm not going to, there might be other arguments that legal people can argue against that. But the Act is very clear here. Some applicants are told to go and do their claims
for gestation at small claims court. This information should be made available to the applicant. It is incumbent on the official to inform the applicant of what her rights are and how to go about completing the documents and assisting to actually meet these requirements. Women are also now being told that they need to go and get a bookkeeper to work out the interest and bring it to court. I'm a bit confused. I'm not too sure where that came in. One would assume that that's part of the training. Prescription. The Arcus versus Arcus case, which we touched on briefly last month. Chapter 5 sections in the Maintenance Act makes reference to judgment and order, and the ECA reiterated that a maintenance agreement is a civil judgment and is subject to a 30-year period as prescribed. This specific case, when the applicant went to Cape Town Court, the maintenance officer continued to tell her that it had prescribed. She then had no choice but to go to High Court. And this is the ruling from the SCA because he appealed. When applicants say there's no prescription, it's 30 years, they're told that they don't know what they're talking about. The Act says it's a civil debt and it's a 3-year prescription. The person comes back to a group like mine in Eugene, and we go, no. It's a judgment debt. It's got a 30-year prescription. I go, but how do I make them understand that? And that's where it's an issue. You're a lay person. You've been told that this is the law, there's precedent, and you're quite confident, but when you're standing there and you're having to defend yourself from a person who suddenly feels humiliated or embarrassed, it's quite difficult. And then, of course, we go, we'll complain, go to the court manager, go to the regional, go to the area, go to the regional, go to national. And by then, it ends up at 29 years. One, not just to navigate the system, but also to be able to gather yourself again, gather the strength to go back into the system that is so abusive. So fortunately for her, her advocate was confident and it turned out well for her. She still hasn't got her money though. But again, the process is used by people who want to avoid paying. Serving of documents. The Regulation 3 directive can be served on the respondent by a maintenance officer or the public prosecutor deemed a maintenance officer or a maintenance investigator. The use of the sheriff should be the last resort of service of the respondent. The use should be limited to Section 9 or 8 service of court documents. Try and use the least expensive and expedient way to get the respondent to court. Interesting, yeah? The only place that I can see where applicants, which is becoming the standard, are kind of told to go and serve documents is try and use the least expensive and expedient way to get the respondent to court. And when this happens, the applicant is not asked if they have the financial means
to go to SAPS. And a lot of them are in different cities, a lot of them are in different provinces. That it doesn't seem to be taken into account. It's go, here's a document, take it to SAPS and go and get it served. I had one of my members who contacted me last year. She stays in Brits. She went to the Brits court and she was told to go and serve the document in Marikana because that's where he works. She's unemployed, caring for her child, so it's not as though she is not doing anything and not contributing. She's contributing. Her labour and her care is just not valued or seen. She made her way to Marikana SAPS. When she got there, they told her that they will not serve the documents to his workplace because they're not going to embarrass him at work. So she made her way all the way back to Brits, where she made contact with me again. I said, you need to go back and go and speak to the station commander. They are obligated to go and serve these documents on the defendant. She went back and the station commander was not available. She approached the officers again and she was told exactly the same story. So I said, well, go back to the court and report it to the court. Because my understanding is that they should be able to phone SAPS and make it very clear that they're mandated to perform the service. After 3 trips to Marikana, she actually gave up. She contacted me again yesterday going, listen, I really need to go and serve this thing. Can I just go back to Marikana with the same order? Okay, unfortunately not, because it's probably expired. The date, you need to go and get a new date. However, I suggest that you go back to Brits. Well, when you go back to Brits, that you insist that the sheriff of the court serve the documents. Do you think that the sheriff will put up with that? I mean, he won't go buy a SAPS, but he doesn't stand there going, oh, Shane, I'm going to embarrass the poor guy. I'm not going to serve this document. Do you think he'll ever serve documents if that's what he's afraid of? So the impacts of that interpretation, one, I don't understand how it is expected. There is no questions. What was your relationship like? Do you have any domestic violence history in this relationship? A lot of women, the majority, the stats are 1 in 4 women go through domestic violence. And those are conservative stats. So if any of them have reported to SAPS, they already have some history of some victimization by SAPS and ridicule. So now they've got to go, oh my God, I've got to go back to SAPS again. My last 6 experiences were not that good. So it's the anxiety and the hesitancy. They eventually pluck up the courage and they go to SAPS. And they're humiliated. Where do you want us to go? Do you think we're delivery guys? Sorry, we don't have vans. You need to come back. We've got more important things to do than to go and drop off maintenance orders. Then she's required to go with him often. And she's face to face. And even if there is no real history of abuse, they've been threatened since they've been warned that they're going to be taken to maintenance court. So even with SAPS there, they are not protected. And it's important for this to be understood. Children are not just rands and cents on a journal entry. They are represented by human beings who have no rights, trying to protect the children's rights. And there's all of this stuff from the background that people are completely oblivious or don't care to take into account. Law is unemotional, but in family matters, there is emotion. And it has to be taken into account. There has to be consideration. Why are women being forced, if they don't have money, to find the money to go and serve documents? A woman
child who is getting a social grant of 460 rand, where is she going to find the money to go and get these friggin' documents delivered? It makes me annoyed because it takes food out of the child's mouth to go and do what is a function of the state. It is the state's responsibility to enforce and the maintenance act, but over and above that, to protect children. Maintenance is a child's rights issue. One of my members phoned me after court. Okay. She recorded her session with the magistrate. He had applied for a reduction. And the magistrate said to her, he's unemployed. She goes, he has assets. He has a house and he has an income from the house. So what do you want me to do? Go and attach his house? So she goes, well, if that's what you have to do, yes, but you can't reduce his maintenance because he has income, and he had 400,000 rand in his bank account 12 months ago. Where has that money gone? And the magistrate said to her, so what do you want me to do? Do you want me to go and attach his house, or are you going to go and find him a job? She said, no, I just want you to protect my child. She goes, are you trying to now tell me how to do my job? Because if you are, you're not going to get this right. Just some background. Before this person was a magistrate, she was actually an attorney who worked for the firm of attorneys that she had gone to. And she was advised by the same person when she was an attorney, well, if he doesn't want to pay or if he tries to reduce, we'll attach his house. How did that change suddenly when she became a magistrate? One. Two, not once did she mention the child. Not once did she mention we will do what we will need to do to protect the child. A Section 6 inquiry had already taken place. She did not even see it in the file. She called the maintenance officer and said, can you please do an inquiry? One had already taken place. She hadn't even looked at the file. This is not a unique experience. Section 33(3)(b) Children's Act of 2005 provides for parenting plans and maintenance. Parenting plans drafted by social workers for children's court and by the family advocate for high court, as well as by the domestic violence court, can be enforced by the maintenance courts. Section 16(2)(a) of the Maintenance Act provides any court can make a maintenance order. Yet we hear applicants being turned away from court because they have a maintenance agreement that is not court ordered by the maintenance court. And when they go, but this is my maintenance agreement, they go, sorry, we have to start from scratch again. It's in the Act. And by then, this is reactive because people applying are just lay people. We're not lawyers. We don't study law. So here it is. Again, now they've wasted a day in court and they have to come back, get this information and go back to court. The Act 99, Maintenance Act 99 of 1998 uses the word may, which means the maintenance officer has a discretion. And then we have fair and equitable, appropriate measures, sensitive and fair approach to determination and recovery of maintenance. And we see it in several parts, speedily as possible, and shall ensure that postponements are limited in number and in duration. Undue hardship, reasonably, proper. All of these words are the words that are used in very important sections that are open to interpretation by different individuals
in different courts, who've been trained or not trained, who studied maintenance in the first semester in their first year of law, who are in positions who haven't received proper training by the department. And these are interpreted not to the benefit of the child. And that's my point, is that in all of this, we lose sight, the officials lose sight, that this is in the best interest of the child. This is to protect the child. How are we making this about criminal and civil law, ticking all the boxes, crossing all the T's and the I's, so that we comply with that? Because we're scared we're going to be sued, and in all of this, we'll just forget about the children. When we have signed international agreements, when it's in our constitution, when we talk about children's rights and protecting children's rights, and so seldom on those platforms is it even mentioned. How often is maintenance or financial support mentioned when you're talking about children's rights? Yet it's fundamental to them surviving. Food keeps people alive. Clothing protects our bodies. It keeps us warm. Education gives us a chance to reach our full potential and to escape poverty. Healthcare gives us the opportunity so that we can be treated when we're not well, so that we can maintain optimal health to reach our full potential. And shelter. They are such basics. It is logical. It's common sense. Justice delayed is justice denied. Maintenance is supposed to provide for immediate living expenses and substance, and should be promptly and properly enforced. Having to approach the court continuously causes hardship for the applicant. In Valentine, the Constitutional Court recognized the gendered nature of the maintenance system. The states show alarming trends of men abdicating their responsibilities towards their children, not just abandoning them physically, but financially as well. Unemployment is highest amongst women. Without financial support, these women depend on the child grant of 460 Rand, soon to be 480 Rand, and depend on extended family, friends, and the communities to support them for shelter and food, for them and their children. They depend on free education, free transport, and free meals for their children. This excludes all the other basic fundamentals, clothing and health care. Women and children become more vulnerable to abuse due to dependency. Women and children are trapped in poverty. Each postponement has a detrimental impact on the applicant and the child. Without food, the child goes hungry and is malnourished, which has long-term health and developmental impacts, which has a long-term financial cost and burden on the state, and diminishes the child's opportunity to escape the cycle of poverty and reach their full potential. If the mother is employed and not getting maintenance, she is economically disadvantaged. She is prone to debt, and it will have a long-term impact on her ability to accumulate any kind of wealth and to provide for her later years. It is common sense and logic that transport to court costs money. It costs money for an applicant to serve documents just to ensure service was done. That is the only benefit of women taking on this, or applicants taking on this responsibility, is that you know that the next time you appear at court, they cannot tell you service was not done. You have a reasonable chance of expecting that person to be there. If you don't serve it yourself, it's a lucky dip. You go to court and it's, oh, maybe he did, maybe he didn't. Let's see what happens. And this is every time you go. 460 rand is substantially below the food abject poverty line. A flip of the coin to feed or to go to court. This needs to be taken into account because every single time you postpone, this is what needs to happen. Can you imagine a vulnerable woman having to knock on doors or ask people for money for transport to go to court again? Do you know that some women exchange sex for money to be able to feed their children or to get to court? Some women, a lot of women, stay in abusive relationships, whether it's with their families or with friends or ex-partners, just to have the roof over their head so that they can afford food to feed their children. Because they know that if they don't stay and they go into the system, it won't help. The Maintenance Act was enacted to protect the child's right to financial support, and the child does not have that sustaining. The child depends on the primary carer, mostly mothers, to approach the court to protect the child's rights. It is the maintenance court's obligation and constitutional imperative to give priority to the vulnerable and to protect the child's rights. It is a responsibility of the Department of Justice to conclude maintenance agreements speedily, at most 60 to 90 days, enforce maintenance orders and prevent habitual evasion and defiance, which currently occurs with relative impunity, and to prevent and avoid systemic failures. The mother has no right or protection in the Maintenance Act. The defendant benefits the most at the expense of the child's rights. Interpreting the Maintenance Act for the benefit of the child is critical in changing the whole child dependency. It is also very important for people who work in the judiciary to understand and to be mindful that the applicant does not have any rights and no protection. And while it might seem that they're just doing their job and they're just following the law, why is it the citizen's responsibility, or why is it falling on the ordinary person in the street? The fact that the Department of Justice does not have the resources. Why is that our problem? It affects our fundamental human rights. I'm so tired of hearing we do not have the resources. They have not been trained. I don't care. And neither should any other woman. There are people like Advocate Races who are doing these trainings. He's doing everything he can, as are many others. Yet the people they are training are not doing what they have been trained to do. Whether it's because they're under pressure, go on strike, demand more staff, we'll join you. To expect you to do 50 cases in one day when you don't have the resources is unreasonable, and your bosses should do something. It is probably against the labor laws that you are required to do some of the work that you do. Tell us, we'll help you. We'll go and toy. We'll bring it to their attention. We're not expecting the people who work there not to be human, but we are asking to say, remember, this is about the child, and remember, we are also human. Remember, we live in a very abusive society, and you might not realize it, but some of your words are hurtful to applicants. When you roll your eyes because a mother says, I don't have money to feed my child, it might be the 20th time you've heard it, but it's the first time she's saying it to you. Respect that, please. It goes both ways. You are there to serve the vulnerable of society. I beg you to be more mindful about how you interpret
and your will to enforce and hold people accountable to protect the child's rights. Thank you.
Okay, I've got some colleagues over here that I quickly want to introduce. The Office of the Master is over here. Advocate Briani Nali is the Deputy Assistant. He's just busy parking his car at the right place. There's no more parking. All the parking bays all around the court, all around the building have been taken. So I showed him where he should park. So he will be over here the next few seconds. And then I'll introduce him. But before he is introduced, Ms. Helga Blood, can you please just stand up? That is Ms. Helga Blood. She is the court manager for Somerset West Court. Next to her is Ms. Ms. Williams Focus, Shannon William Focus. She is a maintenance officer at Somerset West. Somebody that I always rely on. Alison Wildfield is on her way. She's also from Somerset West, and they will be joining us a little bit later. Mr. Malcolm Valentine, can you please stand? He's going to do the presentation on parenting plans. The document on parenting plans that you have read, the old one, there is an updated one. Mr. Valentine will do with the forms. Next to him is Ms. Abogile Koza. She is a social worker, and she will also be able to walking around here. So if you need assistance with the parenting plan, you can call on her or a partner next to her. That is my dear friend, Mr. Peter Ihu. He's from Piketberg, and a few weeks ago, Mr. Ihu as well as Mr. Eugene Opperman did a presentation for the Swartland communities in Portugal, where they are trying to assist the communities of Portugal and the other Swartland areas, Live Lake and all of those places. We are busy targeting all of them, where we will be assisting them to understand how to draft parenting plans, how to do the maintenance application and all of those things. So in case you can't get to Mr. Malcolm or Keith, there are the social workers all sitting over there at the back, willing to assist. Ms. Valencia Steindel will do the presentation for the Master's Office with Mr. Lali. I set up the third floor. So if you, in the lift place number 10, there's a nice lobby, lounge lobby, where the Office of the Master will sit. So if any of you have any problems with wills or your estate and you'd like to let them assist or intervene, just make sure you give them as much detail as possible. And then the Office of the Master, as well as myself, will try and assist whoever needs some assistance with it. Okay, next on the program, Mr. Popperman and I will do a recap of what we've done over the last 2 months as far as the maintenance legislation. So I will hand over and let him do most of it, and I will just fill in. I always put him on the spot. So, Mr. Opperman, will you just do a recap while we are busy setting up? Or just give me a second. I see Mr. Nali is here. The gentleman standing over there at the back next to Ms. Renee Farnford, that is Mr. Advocate Briani Nali, a dear brother of mine, and he is the Deputy Master of the High Court in the Western Cape. He's got a dual portfolio. He's in the Western Cape, he's in Mpumalanga, he's national. So he's not just a Western Cape Deputy Master, it seems as if he's got a national Deputy Master title these days. But he will be dealing with the estates and all of those things a little bit later after we've done the recap. But I will hand over to my dear friend, Mr. Opperman, do the recap as far as what we've done over the last 2 months dealing with the maintenance legislation. And I will just come in case there are any questions before we then go from there on.
Thank you for putting me on the spot. I can't even remember what I had for supper last night. Now he wants me to remember what happened 2 months ago. We started off right in the beginning, and these are all available online for these guys that are new here and have not had the opportunity to attend the previous ones. They are online, so you can watch them. It is quite lengthy because it's a 4.5 hour presentation that we did. It's basically a recording of the previous ones. It is available on the website. We do have a YouTube link as well that we created that. And we also had a separate portal called maintenancematters.org.za where you can log in and you can get all the information of all the videos that we did. So right in the beginning, we started off with what is a maintenance order and when can you apply for maintenance, and we discussed about the J101 form, how to complete the form, what is needed, forms that needs to be submitted to court, the problems that we had with the J101 form. It's not understandable, there's no clear instructions. We actually went through that whole document and explained it word by word or step by step, what to include, what to omit, and how to complete the whole application form. Last time we can remember what we did last time? Anyone? Were you guys? Yeah? Bjorn, can you remember what we did last time? No, we're doing the J107 today. We explained about the processes of maintenance. And we explained how the procedure works in court. Very well, thank you. That's the one that was not, she's sitting in front, so well done for you. Yes, we explained about the Section 6 and the informal inquiry in the maintenance officer, the maintenance officer's office, and we explained about the Section 10, the formal one that is done in court, where the presiding officer will listen to testimony from the applicant, the respondent, the maintenance officer, in order to make a judgment on the application. That was, we were dealing with the first application. First application is when the complainant goes to court in terms of Section 6 because there is a need to maintain. So that is what we've done on the previous sessions.
Increase and decrease sibling maintenance, paid maintenance from grandparents.
Yes, yes. That we did not cover that extensively. The role of the grandparents, what is the complete procedure that you need to follow to constitute proceedings against the grandparents. There is definitely a need for it to address that further. In the further workshops to come, Mr. Giamaratis and I will discuss that. We would probably, in the next session, talk about the differences between, because there's a common misunderstanding for the lay public, the people going to complain for maintenance. They don't understand that you've got two processes working. You've got the civil process on the one side, that's the maintenance application that needs to be submitted to court. So that's considered to be sui generis, something completely unique in nature, but it is very resemblant to a civil procedure. That's on the one side, and then on the other side you would have the criminal aspect, where they would actually jail the bastard for not paying maintenance. I shouldn't say bastard, I'm in the NPA's office. So they would jail him for not paying that, and there's a complete procedure that needs to be followed in terms of the criminal procedure of the act when it comes to maintenance. Then again, when the people come to court, there is also the opportunity when the magistrate or the presiding officer would convert the criminal procedure, the criminal aspect thereof, to a civil procedure and refer it back to the maintenance court. And that is quite infuriating. There's a whole process that needs to be followed, and we will definitely in the next month's workshop, we will definitely discuss that. And then the issues of claiming maintenance from the grandparents will also be discussed. That's basically in a nutshell what happened on the previous 2 ones. We are just waiting then for maintenance to finish up breaking down the NPA building in the process. Is the master ready to,
Yes, Mr. Right. Mr. Nali, do you want to?
Maybe morning everyone. And the first person who will take the stage is Ms.
Strago?
Yeah.
Ms. Strago.
Okay, is she, yeah,
I'm not sure. Because she was just busy with some.
okay. So, let's then have a 5 minute break so that I don't break the whole place down. And then let me just set up everything for them. So let's take a 5 minute break and then we will start then. Okay, people, can we start? The Office of the Master is going to proceed a little bit later because there are two other officials that are not over here. So I asked Mr. Valentine to just continue with his talk on Section 3030 parenting plans in the Children's Act that was already alluded to by Ms. Gray. So I will hand over to you. Before I do that, I just want to quickly introduce one of our other colleagues at the Office of the Master. Her name is Ms. Stydom, Felicia Stydom. She will do the presentation. So she will be on the floor later with Advocate Lali, and they want to talk out of the leads and don't want to use PowerPoint presentation, so they will just bombard you. So please make sure you write everything down that you need to get, because they will load us with some information about the process that needs to be followed in whenever you are dealing with deceased estates. So I will then give them an opportunity. But this is Mr. Malcolm Valentine, a social worker in Metro North. You will explain how many metros there are. I have no idea. So I'm handing over to Mr. Valentine.
Good morning, ladies and gentlemen. How are you? Good. I'm Malcolm Valentine. I'm a social worker at the Department of Social Development in the Metro North. I'm specifically working at the Belleville Court. That is where I'm situated, and I do mediations for the Children's Court there. I'm also responsible for domestic violence mediations, that's the using that they're doing, and I'm also doing mediations of parenting plans as well. Well, normally when people hear, when my contact with clients and I'm on the phone and they hear Mr. Valentine and they see me, then they say, I thought it's like this 40-year-old with a beard and all of that. But no, I'm not. I have been practicing for the past 9 years. I've been doing mediations for 6 years. I'm kind of busy with my masters as well, specifically looking at the needs of unmarried fathers with parenting plans. Because I do feel that is a need in our society that we need to look at that specifically. So that is what I do. That is where I'm coming from. Just to explain perhaps the metros. So the Department of Social Development works in metros. So currently you have the Metro North office. That is where the Guru, Belleville, Belleville, those areas. You get the Metro South, your Wynberg office, Muizenberg, those offices, Khayelitsha, so forth. Your Metro East, and my colleagues over there just need to assist me with this. Your Metro East is your Kraaifontein, your Somerset, your Blue Downs, those areas. You get your West Coast, that is your Freedomburg, your Freedomburg, Malmesbury, those offices on that side, and you get your Eden Karoo, Eden Karoo Metro, and that is your Mossel Bay, Knysna, those areas. Of course, there's more local offices within those metros. I wasn't prepared for that now, but that is basically. So I'm going to start with what we do. Our mediation is a bit different. If we start off with that. So I heard the previous speakers talking about where they come in, clients approach them. Our mediation at the Department of Social Development is a bit different. It is also comes with all of its challenges. We receive the form tools. We are requested by court to mediate in matters of children. So we receive the form tools and then emotions are already on high when the parties come in front of us. Because now, why did you bring me to court? Why are you coming now after 40 years, after so many years when you left me? So emotions is already high and we already in the crossfire when clients then project onto the social worker because now you're biased because you already spoke to the other party before you even spoke to me. So our mediation is a bit different where we are being asked by court to come in and mediate and they really receive the summonses with the court as well. So what did we do wrong? Why do we need to go to court? Why does he want to see his child now? That is the challenges that we have. But I'm going to start. So in maintenance matters, the issue of care and contact between parents might be an issue. Fathers, and here you get your separated, divorced, and unmarried fathers complain during these inquiries that they pay maintenance, but they are not allowed or they are being denied access or to see their children. Now, mothers, they might vary because they might say that, no, I'm keeping my child away because there has been abuse in the past. There's a protection order, there's a case against domestic violence, that's why I don't want to. Or allegations such as substance abuse against the father, that's why I don't want him to see his child. But that is still not reason for a father to be denied access to his child. So, there are things in place that we can do: restricted contact, phase-in contact, supervised contact. That is things that we can mediate, and that is things that we can also ask the court to look into. Now, to avoid all these things, it would be desirable for a parenting plan to be drafted. And the Act therefore makes provision for that. For a parenting plan to be drafted in terms of Section 33 of the Children's Act, where co-holders of parental responsibilities and rights in respect of their child may be agreed upon at the parenting plan. And that is specifically your chapter 3 application. Okay, that's specifically your chapter 3 application. That includes your section 21 unmarried fathers, section 23. Section 23 applications is not the biological parents, but that is your grandparents, your grandmothers, and your grandfathers that can also go to court and apply and also to get those things. It won't be called a parenting plan, but that will be an agreement, a contact and care agreement between parties. Will not be a parenting plan. So those are the things that we deal with. I'm not going to discuss the depth of what the Act says, and so I'm going to speak through all of it. But what you need to know, first of all, and this is also sometimes where attorneys and legal representatives get it wrong. They come to court and say, there's a parenting plan, we want to make this parenting plan an order of court. The court will not just make that plan an order of court. You need to bring a application before court, and that is stipulated in Regulation 6 of the Children's Act. You need to bring a Form 2 before court, and then you need to request the matter to be heard in front of the Children's Court. I'm going to go to the Form 2 because also the Form 2, what I do is I assist clients, especially fathers or mothers. They also come and do Form 2s before court. A Form 2 application that is bringing a matter before the Children's Court. It is important that you know how to complete this form. It is also important that you know that with this form you need to have a affidavit or a sworn statement at the police station. What I tell the parties is, remember, this form needs to go to the presiding officer, and the presiding officer needs to decide whether the application has merits to be put on the court roll. Please be specific and tell and your client to complete these forms as detailed as possible to say what they want from court. The magistrates nowadays, they do say no merit to the application because applicants say he's not paying maintenance, so I don't want him to see his child. The court will say there's no merit to the application. You need to, that part needs to go to the maintenance court. You need to be specific when you bring a matter, especially before a children's court. If it is only for a parenting plan, unmarried fathers, you need to say, I am being denied access to my child. I want the court to assist me with a parenting plan. What parties also do is they attach all the SMSs, the WhatsApp, and the emails and so forth. Yes, you can do so that the magistrate can see, but there is actually some detail and backbone to your application. So part A of this form is the information of the child. That is the information of the child. And the address there, you cannot, as an unmarried father, the child is not staying with you, put your address there. It should be where the child is staying, the primary residency of the child. That is very important. And now, also, these applications end up at the wrong port because you do not know you should apply these applications in the jurisdiction of where the child is staying. That is very important. Most people they apply because I'm staying in the Belleville area. I go to the Belleville court to go and apply at the Belleville court. The court will say, look, there's no jurisdiction, the child is not staying in our area. You need to go to the court where the child is staying, the jurisdiction where the child is staying. That is very important. Part B of the application is your information. The applicant, that is you who want to bring the matter before court, that is your information that needs to go there. Part C would be the person who's having an interest. That would be the mother of the child. If you're the unmarried father, then the mother of the child, that will be the mother's information. It is important, now people also come, we know our clients. So I, specifically Belleville Court, we work with disadvantaged communities. Unemployed, not working. So the parties would come and say, but they don't have an address of the mom. She's staying somewhere in Delft. Making an example. You also know Delft is a developing community. There's always new houses going into Delft. It is important that we at least get a contact number so that we can phone from the court to find out. Or an address where the mom is working so that they can be served. That is the important thing. Part D of the application is we are very specific. You don't have to go in this part into detail what you want the court to do. Assist me with a parenting plan. Assist me with a variation of my previous parenting plan. Assistance of I need to be involved in my grandchild's life. Very specific. In your affidavit, you're going to give that on. You're going to tell the story. Okay? Any questions, perhaps?
Yes, please. You might mention that if the matter has been settled through mediation, a parenting plan, that it cannot be taken to court to be made an order of court. In terms of court and mediation rules, it specifically makes provision for matters prior to litigation. It can be taken to court and it can be made in order of court. So we often have this problem of magistrates' courts, the clerks send mediators away because they don't know their own court rules. The court rules make provision for that. And there's no reason why it cannot be applied and implemented.
Perhaps just to go back to that. So the thing is, what I was referring to is that whatever matter you bring before court has to be on this form. So this form, the court wants this form. Even if it's the mediator coming to court, you need to attach a form 2 to bring the application. This is what the Act is saying, Regulation 6, to bring a matter before in front of the children's court. It needs to be attached. So what the mediators do is they attach their form 6, they attach their form 8, they attach their form 9 and 10, but there's no form 2 attached to it. So the clerks of the court, they don't see it, they don't think it, because there's no form 2 to bring the matter before court.
Yeah. So the clerk of the court should then inform the mediator who takes the matter to court. Please fill in form 2 for that purpose. But the problem that we do have is they are of the opinion that you must bring an application. You cannot settle a matter out of court and then bring it to court. The court will specifically make provision for that. And it saves a hell of a lot of time and money.
And I agree with you, 100%. 100%. Therefore, we have to also educate. That is the important part, and that is why this dialogue is so important. Okay, so remember with the Form 2 application, it has to go, and you have to attach your affidavit response statement or your documentation. If you are a mediator, you have to attach those things. I am going to the next part of the section, P3, would be your parenting plans. And I'm going to go to our form. So this is my template. Apologies, I didn't get it, my template. So this is basically the template that we make use of. And I'm going to speak through the templates that we make use of. So that is part one would be the parents' details, and part two, mother, father, all the identifying details. Then the details of the child. It's not me. Just after the introductions will be the name of the mother, the name of the father, there will be the biological parents of the child concerned, and that is just identifying. And then the first part would be the parental responsibilities and rights. The first part would be the responsibilities and rights. And it is important that we know that in terms of section 21, the unmarried fathers, that those fathers acquire. They need to acquire their parental rights and responsibilities before we can proceed with anything.
So before Form 2, must they do something before you get to Form 2?
No. So they come and apply. Those things will then come, and then in the mediation session, then we will address that.
So they still fill in a Form 2?
They still complete the Form 2, yeah. So this is now after, so what happens, after Form 2 has been completed, it goes to the presiding officer. They see whether it has merits, they say, okay, merits, go to the mediator with the court date, they get the court dates, they come to mediation at court before they go for the court proceedings. So then they come to me for mediation, and I need to discuss all of these things with them. So what I do is I normally ask, are you the father of the child, were you married? I need to establish all of those ground rules things. I need to establish, have they been in a relationship in terms of section 21(1)(a), or will it be in terms of section 21(1)(a)(b), and with all those three aspects at the bottom. If not, and the mother is saying, no, it's not the father of the child, but he's saying it's the father of the child, we need to refer, it can't be mediated, there needs to be paternity case that has to be done in this matter. But then we do section 21, and then part 2 of that would be your section 18, where both parents are co-owners in terms of section 18, 2, 3, 4, and 5 of the Children's Act. We then discuss primary residency, that is normally with the biological mothers, and then also just something that you have to put in nowadays is with death of parents. And this is normally a shocker. So I've learned that when I put in that in there, and then parents come see that, okay, this is serious business. It is actually about the child. It's no longer about my feelings, why the relationship didn't work out between the two of us, but it's about the child at the end of the day. We do, part 3 of the parenting plan would be your maintenance. So we do maintenance with mediations, with parenting plan mediations. However, I need to state this as well. The children's court presiding officers they don't like doing maintenance with parenting plan. Because the issue becomes about maintenance and then not about care and contact anymore. So then mediation is normally unsuccessful. So what we then do at our local level is we refer the parties to the maintenance court when we see that we cannot settle in terms of maintenance agreement. Then we refer the parties to the maintenance court, and then we continue. So then we scrap out, and then we say parties are being referred to the maintenance court, and then we continue with the care and contact. Because remember, children's court is also about the care and contact that the child has the right. The child has the right to be involved in both his parents' lives. So it is about the best interest of the child. Part 4 of that would be then the care and contact. That would be, will we discuss supervised contact? Will it be alternative weekend contacts? That is what the parties discuss, and that is what they need to come and tell me what is going to work for them. This is their process. In mediation, I normally inform the parties, this is your process, this is not my process. I do not make recommendations as a social worker. You need to decide, because this is going to become an order of court in agreement of both parties. midweek contact.
Just a question on that. When the child is received into the father's care during school holidays and over weekends, why do you deal with that as contact? It's rather care. Both parents have full parental responsibilities and rights, including care. So there's not just one carer for the child, there are two carers.
Yeah.
The father as well. So the authority on these cases clearly indicate that receiving the child over the weekend is receiving the child into your care,
Okay.
as well as a school holiday.
Yeah, so it should say contact and care. Contact. Okay. We open, it's a learning process. So this is just templates that we designed that is working currently. So it should be contact and care. So this is contact over special days, the child's birthday, Mother's Day, Father's Day, the mother's birthday, the father's birthday, school holidays that we discuss, and also religious holidays that the parties can decide that we include, and the parties can agree upon those things. Part 5 in the parenting plan will be your joint decision making. Those joint decision making is normally what we say that the parties need to adhere to, and from here going forward, this is part of co-parenting. So that is being discussed with the parties. Part 6 of the parenting plan would be the view of the child concerned, and we normally say that this parenting plan would then be in the best interest of the child concerned. And then parties initial each page. Parties have to initial each page, and then they also have to sign the document, and they sign the document actually in court. And then
Just about the children, you see the children.
or get to it now. So that is the challenge that we're sitting on. So the challenge that we're sitting on is parents, when they receive the Form 4s to appear in front of court, the Form 4 clearly says that you need to bring the child before court. The child also needs to come with it so that we can see the child as well in mediation. However, they do not bring the children. And that is what the presiding officer has been going on about. And she's saying that when it's maintenance court, you bring the child to the maintenance court. But when it's children's court, you do not bring the child. Then there's an issue with bringing the child. So most of our cases, we cannot see the child, so it will only be between the two parents of the child concerned. If there's issues, ladies and gentlemen, where we see that the parties are still arguing, and they're saying that the child do not want to see you. The child was 13, 14, 15 years old. I do ask the parties, well, we're going to continue with mediation. I'm going to ask the court for a postponement so that we can interview the child as well and get the voice of the child with regards to mediation matters.
In terms of section,
There's a question at the back.
I have a question with regards to peer contact. Even though there's mother and father, but isn't one party seen as a primary caregiver and the other party as kind of a secondary? So I'm just wondering, is that still in the act or isn't there? Because if the child stays with mom, say from Monday to Friday, she's seen as a primary caregiver, and then she has most of the time, I believe. And then the dad has maybe seen as a secondary. It can be vice versa. So can you elaborate on that?
Yeah. So I'm trying to stay away from defining that you are the primary and you are the secondary. That is just gonna open up another can of worms. I do try to stay away from it. So what I do discuss and what the Children's Act is saying, primary residency of the child. So we discuss the primary residency of the child where the child will be staying predominantly.
Just about the children, the voice of the child, it's mandatory. Section 10 says the voice of the child must be heard.
Yeah.
You cannot finalize a parenting plan without having the voice of the child being heard by a professional person. Yeah. So I don't know how these parenting plans go to the court.
Yeah.
It's not in terms of the act, it's absolutely mandatory.
And those are the challenges that we're sitting with that. And we get, I'm going to get to it, and there's also a question, I'm just going to take that question and I'm going to take that question. So that is the challenge that we're sitting at court currently, and we get these volumes of Form 2s that we receive for parenting plan. So what the court is normally saying is, look at between the parties. So if they agree in terms of the best interest of the children, then I'm going to make it an order of court. And it's not supposed to be that way. Legislation is saying the voice of the child.
But the magistrates are ignoring what the Children's Act says.
I can't say that. I'm not going to say that. I can't say that. I'm not going to say
They
that.
do.
But it is what is happening in practice. The reality is this is what's happening in practice. There's a question after that. Yes, you.
The one of is trying to identify the child. Even though you are no longer seeing the mother to the child, you are even, members want to take time to the child, but also be present, be there for the child. And then after it's like, okay, let me have a baby, with other babies, not with this other lady. And then the mother decided to repatriate the child to the okay. And then the parents, after my right as a parent, after being and I believe that I have the right to join somebody with the child because I was there with the child. But the mother denies and access the child. That makes, I didn't know, exactly how to, quicken, relevant information, how do because I also have a confidence, similar to where I'm working at this court. Sometimes I don't know how to explain the situation to the child. How to go about, giving such cases.
Yeah. So we do get those cases a lot as well, where the mother just leave with the child to the Eastern Cape, so that the father doesn't have contact with the child. What we normally do is, unfortunately, those fathers have to go into the Eastern Cape to apply at the Eastern Cape Court to have contact with his child. That is unfortunate. But also, that father can approach the Department of Social Development within that area. Because remember, this can also be initiated from social workers. And social workers can also bring an application before the court. Okay? They can also mediate the matter and then bring the matter before court when they've settled the mediation. There's been a question. I need to continue, complete the presentation as well.
Could we just ask, could we just ask that we keep the questions till after all the presenters, because we're running a little bit behind schedule at this time, and we would love to discuss each and every case, but could we wait till afterwards? That's the one reason. The other reason is there's only a microphone in front. So if you sit at the back, the people, the viewers in doing it virtually cannot hear what's the question. So let's be wary about that, please, so that we keep the questions for afterwards. Thanks.
I'm going to skip this part of the presentation because we've been discussing maintenance too late. However, I need to say when we do in the Form 8 and there's a maintenance agreement, we do get legal representatives that informs the client that you do not have to pay that maintenance because it's not an order of court. That notion is still running. That a parenting plan with a maintenance agreement is not order of court. Your section 35, it's an order of court. What the children's courts do now as well, they do your section 45 inquiries, contempt of court orders. And then they do refer those matters if they find you guilty in terms of contempt of court to the MPA for criminal prosecution. They wanted me to include foster care plans. There's no such thing as a foster care plan. It is a foster care. So I'm just briefly going to run through foster care. What is foster care all about? So foster care is your Chapter 9 application. That the Chapter 9 is when the child is being found to be in need of care and protection. Meaning that child doesn't have a parent or a guardian who is suitable to care for him. So foster care is the temporary placement of a child who is found to be in need of care protection, that's in chapter 9. The child is placed in the care of a suitable person who is not the parent or the guardian of the child. The Children's Act, chapter 12, your section 150, 155, 156, and also your section 180 to your section 190. Those are sections which deals with your foster care placement. Foster care placement is also a period of 2 years. It can be extended up until the child is 18 years old when both parents of the child are deceased. Then your foster care orders can be extended up until the child is 18 years old. But foster care is for a period of 2 years, and after every 2 years, that foster care placement has to be reviewed. You need to see whether the parents' circumstances are still the same, and there's the responsibility of social workers to have to work towards family unification. So the social workers get an opportunity in 2 years to be able to work with the parent to see if the substance abuse has been the problem, why the child has been removed. We need to see whether the parent has gone through the rehabilitation process and whether we have worked with the parent to get that parent back up into their feet so that the child can be reunified with the parent. Because reunification is the ultimate thing that we need to work towards, and that is also in the best interest of the child concerned. Purposes of foster care is to protect, nurture children by providing a safe and healthy environment with positive support, promote the goals of permanency plans, also respect individual family by demonstrating respect for culture, ethnic, and also community diversity. Contribution orders. There's one magistrate presiding officer who's a Bellville Court, Mrs. Smith. She loves doing this. If parents of means to still support their children, and the parents and the child will be found to be in need of care protection, she does make contribution orders against the parents to still pay while that child is in foster care. And then that child won't just be the responsibility of the state, but the parents also have a due responsibility to pay maintenance towards their child. I've indicated that our responsibility as the Department of Social Development and also your NGOs that work under the Department of Social Development, was funded by the Department of Social Development, that's your DISA, your RCFF organizations. We are mandated to support in maintenance matters, parenting plan matters, care and contact, and that is your section 1821, and then agreements, care and contact agreements between biological parents and grandparents, that would be your section 23 mediations that we do, and we do the parenting plans and those care and contact agreements. Non-compliance of parenting plans, those are also things that is a challenge in the field of social work, and also with us, because parents do not simply comply with parenting plan. They do not comply when it is the turn for the other party to have the child, then the child is too sick to go to the other parent. So that is non-compliant. So what I normally tell the people, the other parent also has the responsibility to care for their child while the child is sick. There's a court order, and you are going to get into trouble in terms of your section 55 application that's going to be held against you, or the father can go make, or the mother can go to the police station and make a criminal case against you for non-compliance of a court order. As I mentioned earlier, that the children's court, they can do inquiries in terms of contempt of court in section 45, 2, and when found guilty, they refer the matter to the NPA for criminal prosecution. Those are also in terms of your Maintenance Act, your section 31, and also the prosecution can then prosecute in terms of section 305. I'm not going to go into that, but do know that the Family Advocate's Office also has a due responsibility when it comes to mediations. Your section 10 And then also they have the responsibility to mediate in divorce matters. And also they have social workers in terms of these investigations that needs to occur. So mediation would be unsuccessful when these allegations of sexual abuse, drug abuse, severe drug abuse where the child is being exposed, then the mediation would be unsuccessful, and then we cannot mediate. Then the matter has to be referred for a social worker to investigate the circumstances. Those are my contact details. I'm not situated at number 48 Queen Victoria Street. I'm situated currently at Belleville Children's School, but those are my email address and my contact details. Thank you very much.
Mr. Valentine, we're not going to have questions now. I will quickly give Mr. Opperman, thank you, Mr. Valentine, Mr. Opperman an opportunity to respond. And then after I saw that there were hands up while Mr. Valentine was presenting, and then I went to them and told them, just give us an opportunity to at least get for our work and then ask questions afterwards instead of making it being a question and answer session, because we're not going to get to our program the way we are going now. So that's the reason why I stopped some of the people. But I still got the gist of your questions. So if you don't ask it now, then we will make sure that we do answer it online, or we will then put a question and answer on the www.childmaintenance.org.za website. The other forms that Mr. Valentine referred to, we will post it later on this afternoon or this evening on the website. So those of you that want to have a copy of the Form 2s and all the other forms that were mentioned, we will make sure that you do get copies of those. What Mr. Valentine said as far as that the children's court magistrates or presiding officers that are called commissioners don't want to get involved, that's true, and that's why Felicity also mentioned Section 16.2 as far as any court can make these orders. It's important that we start advocating for the children's court, the domestic violence court, even the bail court can make an interim order to ensure that there's at least some type of financial need that is being complied with immediately, because they can make interim orders in terms of Section 10.6 of the Maintenance Act. So if you know these things, and that's the reason why we are all here, if you have that information firsthand and say that Section 10.6 says that we must limit the number of postponements and duration, and we know those type of things, then it will take it a little bit further than just no order being made, especially the children's court. And I want the commissioners in the children's court to know that in terms of Section 10.6.2 of the Section 16.2, Section 16 subsection 2 of the Maintenance Act, it says any court can make that order. There's nothing that stops the children's court from making that order there and then. That interim order of parties are there, because even though they didn't do a proper financial inquiry, I understand that. But at least how much are you earning the way some maintenance officers are doing it, fillaging, okay, that's the order, without doing a proper financial inquiry in terms of Section 15 and Section 16 to deal with the fair and equitable part of what Felicity was speaking about a little bit earlier. But for now, the reason why we're here, we get the information, we take it further. So if you're sitting in front of the commissioner in the children's court, there's nothing that stops you from saying, but sir, in terms of Section 16.2, any court can make this order, so why can't the children's court in this specific case make it? But what Mr. Valentine said is true, that in most cases, even in the divorce courts, I found matters, and I dealt with the matter quite recently in Grabouw, where the Somerset West Court, the divorce court didn't want to deal with maintenance. They said, listen, we're just getting you divorced, the two of you must just get away from one another. So they dealt with that, and then afterwards said that they can go to the maintenance court and deal with the maintenance issues there and then. But if you read the Divorce Act, Section 7 of the Divorce Act is contradictory to what the divorce orders or the divorce courts are doing these days, because then it becomes problematic for the maintenance court to deal with it. It's a little bit technical, but I will deal with it in August. If you want me to explain that, I will deal with it. We will get to it. It's just that I don't want to complicate things. Let's get all the easy things out now, and then we will deal with the challenges that we are dealing with. But for now, on Saturday, 26 March, what do you go away with over here? Any court can deal with it. That's what Felicity said, including the children's court. Mr. Valentine said that the children's court commissioners don't want to deal with it, but section 16.2 says any of them can deal with it. Section 10.6 says we can't have cases being remanded from January till March or January till, and I know these cases that have been dragged out for a long period of time, but section 10.6 of the Act is clear. Limit the postponements and limit the number of remands. And even in a case where they do it, section 10.6 says interim orders can be made, and that's what we want you to ask for whenever you get to the maintenance court or the children's court, is get an interim. All right, Mr. Commissioner, you don't want to deal with it, but please make an interim order. You know how much he's earning, you know how much she's earning, whatever the case is. But please, this is the needs of my children now. Let's deal with that now. Judge Yvonne Mokoro said in the Valentine matter that these type of hurdles we need to get out of the way. And the way we get it out of it is if we are informed of what our rights are. So there's nothing that stops you from saying to the magistrate or the commissioner, but Ms. Commissioner, Ms. Magistrate, why can't we, in terms of section 16.2, deal with it? Because any court, including your court, can deal with it. I'm going to hand over to my dear colleague to deal with his presentation. I already said 107 now, so I'm not going to say what he's going to be dealing with. So I will hand over to Eugene Opperman. And he will deal with the slideshow.
Thanks, guys. Just before we start off, you know that I'm passionate about maintenance and family law, whatever. Last time we gave you masks stating the wording begging for maintenance, which I used in court and I was frowned upon quite a lot. This time I had 2 stickers printed. It's not enough for everybody, but you can come and collect some of that if you want to find more. I'll give you one. The one says, huge financial burden on board. You can put that at the back of your car. If you have a child, that's also fine. Mr. Private said, if you don't have any child, if you're referring to your wife, you can put this on your car. And then the other one just says, every child matters. So I've got a couple of these, find me and come and collect these. Not a problem, right? Let's just start off. Right, so I'm going to deal with the rescission variation and the suspension of maintenance orders. I'm going to briefly touch upon what's the difference between child maintenance, spousal maintenance, the frequency of variations, how to complete the J107. That's the form that you need to complete once you want to go to court and ask for an increase of maintenance. Sorry for the master's office of breaking down the display. Right, then a very contentious issue that we're going to discuss, and I'll run through some case law. I'm not going to make it too technical for the people that are not technically or legally inclined. What is considered to be good cause in terms of the rulings of courts? We're going to look at some of the factors that the courts will consider and the deterioration of the respondent's obligation due to subsequent marriage that we get quite often, as well as the cost of living. We're going to talk a little bit about variation or the respective variation of maintenance orders, and then the drafting of a founding affidavit that you could conclude with your application for increase in maintenance. So, right, the statutory division or the statutory compliance area that deals with these type of orders asking for an increase of maintenance is also dealt with Section 6. where it says that whenever a complaint is made and that good cause exists to vary or discharge a maintenance order, then this complaint should be lodged in the prescribed form, which is the J107 form. It should be lodged with the maintenance officer, and the maintenance officer has an obligation. He must investigate the matter. He will obviously include the assistance of the maintenance investigator, and he may then further institute an inquiry into a maintenance court that has jurisdiction. So this is the slide that we had last time as well, just briefly explaining you the difference between the section 6 and the section 10. It all starts off with a complaint at the maintenance officer. After you have the J107 form and you go to court and you lodge it there. The maintenance officer then employs the services, or not employs, he uses the services of the maintenance investigator. This whole financial issue then gets discussed and gets investigated. And the investigation needs to be completed before the matter is then transferred back to the maintenance officer. The maintenance officer then will then take the file, look through the file, and then get the parties in as an informal discussion at the maintenance officer's office. That is the section 10. The section 6. If the parties are not in agreement and they cannot see eye to eye, they have got differences of opinion with regards to the expenses or whatever the case might be, then the maintenance officer may transfer the matter to a formal inquiry in terms of section 10 of the Magistrate Act. The section 10 then is then dealt with in an open court under oath. Remember now under the section 6 inquiry, Dion, you have any slides? The section 6 inquiry is not under oath. The section 6 inquiry is not done under oath. Yet the section 10 inquiry is done under oath. So if you lie in a section 10 inquiry, you could be charged with perjury. That's done, like I said, in front of the magistrate. The magistrate will listen to testimony and then make the necessary ruling after. Right. I said that we're going to distinguish between the child maintenance and the spousal maintenance. That's also very important to distinguish between these two. But for purposes now, we are going to talk a little bit about child maintenance. That's what we're here for. Now remember that there's always been a common law duty of support. Regardless of any act that ever existed, there has always been common law duty of support where a biological father needs to support his offspring. And the maintenance courts and the High Court and all the other courts and other forums are there to enforce that common law duty of support. There's a common misperception in courts that people go to apply for maintenance as if they were going to apply for a SASSA grant or whatever. No, it's not. You do go and you do follow a procedure, but the whole misconception about going there to apply for something, no, it's not. You're just using the court system to enforce the common law duty of support of the father not paying for the maintenance. Paramount to all of this is the best interest of the child, and that was actually stated in the case of Diabate, where they said that once sufficient cause is shown, the factors that are to be examined are primarily those of the children. That was also emphasized in Green, where they said that children, as they get older, the cost of maintaining them would obviously increase. Frequency of variation, that we get quite often on both my group and Felicity's group, on the Facebook groups, where they ask how often can you apply for an increase in maintenance? And will an application for maintenance increase succeed, even though the short time of period has elapsed since the original window was granted? The leading case here would be the Watson case, where it stated that such an application would not be refused if the true interest of the minor child necessitates such a change. Again, if there is a necessity then and it is served by the best and the true interest of the child, then no court would refuse such an application. In the case of Schmidt versus Schmidt, it was also held that the Maintenance Act makes provision for unquantified amounts. You go there and apply for maintenance. and your J101 form, and an order gets granted. So much for school fees, so much for medical, so much for whatever the case might be. But those are all unquantified amounts. Anything can happen. Extramural curricular activities might have not been included in your order, and that might change. The child might need ADHD medicine or Ritalin for the mother or the child, for that matter. But yeah, that could change. That could change. So those are all unquantified amounts that would actually make variations of any court order necessary. The onus and the role of the court. There's a difference between the High Court and the Magistrate Court. The reason why I'm bringing this in is because nowadays there is a tendency for a lot of people to, because of the, let's call it dysfunctionality of the lower courts, to approach the High Court thinking that it would be a faster route to go. In the High Court, the onus is on the party seeking the variation to show sufficient cause. So you bear the onus of proof when you bring an application in the High Court. But if you bring an application in the Maintenance Court, there is no such thing of onus. The Maintenance Court is a creature of statute, which means it was enacted by law to operate as a lower court. They need to follow the same set of rules. So in the Section 6 and the Section 10 inquiries, there's no such thing as onus. There's no such thing as you need to prove and you need to prove. The responsibility of bringing the information and the evidence before court vests in the presiding officer, the maintenance officer, the applicant, and the respondent, and any other party that might be affected thereof. This was very clearly stated in the Book versus Book case, where they said that even despite that the parties might be legally represented, the presiding officer and the maintenance officer share with them the responsibility of gathering the evidence. So if you have a magistrate sitting at the top there and they just say, I'll present your case and go ahead, you say, no. You can actually come down to the arena, figuratively speaking. You won't just flood it down with his robe, but he would come down and he needs to be part of this whole negotiation process. It's not a criminal trial, it's inquisitorial. So he needs to play an active role in establishing what amount would be fair, equitable for the increase of the maintenance. Now, the completion of the J101 or 107 form, that's the application form for substitution. We call it the increase one. For the additional officers and for the attorneys here, I refer you guys to the Section 6 and 10 of the Maintenance Act, as well as the DOJ Code 26 and the NPA policy on part 26 thereof. So this J107 form, where do we get that? The J107 form can be collected at court. It could also be downloaded from the website from the Department of Justice, right? Now, in terms of the DOJ Code 26, this form, the DOJ 107 form, needs to be completed in black ink. Do not use a pencil, do not use a pink marker, use black ink to complete this. There's also provision in the DOJ Code that the maintenance clerk, not the maintenance officer, but the maintenance clerk, needs to assist people in completing this form. This happens very seldom. They just get stuck the form and say, here you go, happy go lucky, there you go, complete the form. They don't know what the form is about, how to complete it, there's no instructions, they were just given the form. You, as an attorney, can advise your clients that they can actually go back to court and insist that the clerk, the maintenance clerk, help them and assist them in completing the J107 form. There is also the responsibility of the maintenance staff to advise the applicant what good cause is. That also never happens. Remember now, this is a lay person coming to court. They don't know that they have to prove just cause or good cause. And it's up to the maintenance staff to advise the applicant what the implications there are. Therefore, it's highly recommended, and it's also contained in the NPA policy code, to include a founding affidavit, and we'll get to that later. Founding affidavit is basically just a statement supporting your application for increased maintenance that needs to be filed together with that. In your handout, there's also an example, I'll give you the page numbers later, of an example of a founding affidavit, and I'll briefly touch on that in a while. Looking at the J107 form, this is a typical government form, drafted by people not knowing how to properly complete forms and do not have any reasoning and logic when it comes to that. There's no indication how to fill in the form, instructions, know-how, step-by-step guide, nothing. But let me explain why I say that. So on the left-hand side on the screen, you would see you need the details of yourself as the respondent, the applicant and the respondent. You would also need to fill in the details of the previous existing order. That you need to fill in the red boxes that is contained on the screen right now. And then also, if you have a copy of your maintenance order, the previous one or the current one, you need to include that as well. Now we come to section 2, the second portion of number 2 of the form. Here they want you to fill in what amount of increase do you need. So how ridiculous is this? You didn't even have the chance to work out how much increase is really needed. But yet again, following chronologically, they want you in number 2 to include that. So our recommendation would be, leave that section out and complete that right at the end. Leave that out and complete that right at the end. Then you would realize that the normal, this J107 form, increase for maintenance form, resembles basically identical to the information needed from the application that you initially started with your application for maintenance. You need to disclose all the assets that you have, that there might be changes in your assets or your investments. You calculate all that. On the right-hand side top, you would see that you need to establish the income. You need to tell the court what is your income. Now, if you are gainfully employed, obviously you would have a pay slip attached that to your application as well. But you can also you'll get from your pay slip, you'll get the details from, like, what is your deductions, what is your pay as you earn, to come to your net salary at the end, right? Then we come to a very contentious one, and the courts do not understand how to complete this, and if the courts don't understand that, then surely the people need to fill out the form wouldn't either, and that is the calculation of the expenses of the child. Now, those of you guys that attended the previous NPA dialogue, we discussed this in length, but just as a recap, it is not a 50-50 basis. There's 2 columns. There's one column for self and there's one column for children. It is not, I'll repeat again, it's not a 50-50 split. Case law, this is a good where it clearly states that what you need to do firstly is you need to establish how many people are there in the household, right? Everybody knows that. There's 2 people, mom and child. Then you add a value. You add a value to each of the adults. You add 2 values to an adult, and you add 1 value to the child. So if it's mom and 1 child living in the house, there's three shares, 2 for the mother and 1 for the child. So what happens now? If your rent or your lodging is 1,000 rand, that needs to be divided by 3 because there's 3 shares. And logic would dictate that 1, the child's portion, out of the 3 portions, would be the child's portion. So the child would be liable to 1/3 of that lodging amount. And the mother would obviously carry the burden of the rest. She needs to pay 2/3. This is a tremendous task for us, and we get that each and every day. People do not understand how to work. There is, on the website, there is an example, an explanation, exactly with more details and examples on how to complete that. So you continue with filling in the 2 columns, the self column and the children's column, up until you get to the end where you get the total amount. Then you add up everything in the child column and you add up everything in the self column. And then you would be in a position to see this is the needs of the children in terms of an increase in maintenance. So I had people filling in this form after I explained it to them, and they would actually need less than the original court order. So what good cause would there be for them to ask for an increase? But they heard that they can ask for an increase. This is fairly scientific. This is fairly scientific and it's quite easy to complete. Right. After you've done this, after you've calculated what amount is needed as an increase, then you can go back to the number 2 and complete the number 2. If it's stated under the total column that you need 2,000 Rand for maintenance, then you add that there under section 2, and then you split that amongst the children that you have. You state there you want 500 Rand for that one, 500 Rand for that one, you can up to 1,000 Rand, whatever the case might be. Very important also, there's a portion at the bottom, and all we have a lot of applicants that are insisting on winter clothes, summer clothes, Christmas clothes. Now, personally, that's out of my frame of reference, but we get that quite often. I see it on my group, and I see it on Felicity's group quite a lot. They insist that needs to be paid. So if you had it that in your previous order, the payment of school fees or for maintenance specifically, or for extramural activities and for holiday clothes, Christmas clothes, make sure that that is also included in this application form. Because this application form will override the previous one. So if it wasn't included there, you might run the risk of going back to court and have it altered again and start the process from scratch. Briefly, just the duties of the maintenance officers when it comes to the completion of the J107 form. It is the task of the maintenance officer to establish what good cause is. Now, this links with what Felicity says, because there's a kind of applying of minds where the maintenance officer needs to apply his mind and then establish subjectively if there is something like good cause or enough reason to bring an application for increase in maintenance. Like I said, the maintenance officer must see to it that the complete order has been substituted. That everything included in the previous order is also contained in the latest order. So now we come to the nitty-gritty and we come to the good stuff. So what is good cause? Now, good cause, sufficient cause, under the Divorce Act previously, any maintenance order may be rescinded, varied, or suspended if there was sufficient reason for that. Now, the corresponding provision in the previous legislation, which dealt with these variation orders, talked about good cause. Then came the case of Levine versus Levine, where the judge actually clarified that. And he said, you know what, this good cause and sufficient reason thing, it's actually basically the same. And the biggest reason why he said that, because when they looked at the Afrikaans Act, both indicated the same phrase that were used, namely for indemnity. So why is this important? It's important for us as legal practitioners and people needing to know what is the difference between good cause and sufficient reason, is that even though there might be cases heard before the Divorce Act came into operation in 1979, and in those terms when they discussed what is meant by good cause, it's still relevant up until today. That's why I brought that in. Right. As far as a definition of what is good cause is concerned, the courts are of the view that a precise definition of the term is neither possible nor desirable. And I can understand that because each and every case needs to be dealt with on merits. You can't have a numerous clause where you have a certain set of definition and everything needs to fall into that definition. And that was emphasized in the Petersham case, where from the onset it was also emphasized that as far as possible, the person should be held to his undertaking to pay maintenance. Just in short, and we alluded to that, the inquiries conducted in the maintenance officer's office in terms of section 6, and that the maintenance officer may then refer the matter if they could not see eye to eye, to the magistrate court for decision in terms of section 10. This is basically just what was already said. So this is, maybe I should just emphasize this a little bit. So what happens before the inquiry? Before the date of the section 6 inquiry, the maintenance officer must investigate the matter and determine good cause. So there's a responsibility on the maintenance officer. He needs to take the file, he needs to investigate. Obviously, the maintenance officer will not do that. They will not. They will probably, because why? Not because they're lazy, because they're overworked, no. But it is because they could use the services of a maintenance investigator to do that. But the sole responsibility for that rests on the maintenance officer. Right, so once the maintenance officer is satisfied that there is a good reason, a good cause that the parties can apply for increase in maintenance, the parties will be summoned to court in terms of a regulation 3 directive, which is basically just a piece of paper inviting them to attend the office of the interim office of the maintenance officer to informally discuss the matter and then come to some kind of agreement. Yes, this is just a little bit more practically. The maintenance officer studies the application, root cause needs to be established. The maintenance officer also looks at the needs and the needs, and then after that has been done, they invite the applicant and the respondent to attend to an inquiry in the maintenance officers, and the applicant then needs to give reasons, sufficient cause. And then there's an investigation into the financial affairs of the parties as well as an active negotiation process. So this is where Catherine alluded to, and Doris Robertson also alluded to, where there could be a need for mediation training in regards to this type of inquiries. If the parties then consent, the consent order could be made, garnishing order or a voluntary detachment order could be granted. If the other parties are not in agreement, the matter could be referred to court in terms of section 10, and the magistrate will discuss the matter and will decide on the matter. So what would happen if the maintenance officer feels that you do not have a case? That happens quite often. They look at the file and they realize that there is not enough cause, no reason for an application of increase. What would happen then? If a party is then still aggravated, the matter would be sent on review. It would not be sent on appeal because only court rules would be appealed, but it could be sent on review. Right, now we come to the section 10 inquiry. That is now after the parties have not come to any kind of agreement, and the matter is then transferred in terms of section 10 to the magistrate for hearing. In the maintenance court then, when they are doing a section 10 inquiry, the applicant would have the opportunity to testify, the respondent would testify, and the maintenance officer will offer his or her recommendation as to the increase of the maintenance. The court will then listen to this, to the evidence, and make a necessary ruling. It could be then that the increase is granted, and the increase is not granted. We said previously that the section 10 is inquisitorial, which basically means, like I said, it's not a criminal trial, and all the parties play a very active role in establishing the possibility and the viability of increase of maintenance. If you are still not happy about the magistrate, which we very seldom are, if we're not happy with that, our only recourse would be to take the matter on appeal in terms of section 25. Factors that need to be taken into consideration in the court. In terms of the Whiteley case, they said that full disclosure needs to be made regarding the financial position, and there could be a negative inference made if the parties are not truthful to the court. I included this slide for divorced spouses because the divorced spouses and the maintenance regarding that is a little bit different, and it's considered different. Different factors are brought into consideration, because in terms of divorced spouses, where parties were, who's ringing? Okay. So in terms of divorced spouses, where parties were previously married and there was subsequently a maintenance or a spousal maintenance order made, when considering the determination of what is sufficient reason, the court also takes into account the factors that it used to come to a conclusion and make the maintenance order initially. In the Hancock's case, they said that the conduct of the parties, the age, and the ability to support themselves needs to be investigated. They also very clearly said that, you know what, even if a respondent is able to pay an amount of maid, it's not up for the mother to ask for exorbitant claims. And that was said in the job releases last. Subsequent remarriage, whoa, that we get a lot. I'm very angry. You get a lot of angry mothers because now ex-hubby or ex-boyfriend found somebody else, and and now they've got a child together, and they just up in arms. Right. First of all, what the courts would do is they would try and establish whether the deterioration is due to circumstances beyond that person's control. I failed to see if he made a baby, how they could establish if it was beyond his control, but that's beside the point. So if he himself has been the cause of this deterioration of his financial circumstances due to his own accord, for example, by entering into a second marriage or having another child with somebody else, the court will be less inclined to be sympathetic. And that was so clearly stated. In the Hancock case, there's the Hancock case, there's the Beneke versus Beneke case, as well as the Galway case, where they all reiterated this. If it was on your own accord, if it was your own fault, the courts will not be sympathetic there too. Very important, section 15.4 of the Magistrate of the Maintenance Court Act, where it says that no provision of any law to the effect that the obligation incurred by a parent in respect of a child of a first marriage shall have priority over any obligation of any other further children, whether within or without wedlock. So it's not like in firstborn, first served, first come, first served. It doesn't work that way. It doesn't work that way. Remember that the best interest of the child is paramount. So all children, like I said, every child matters. Every child matters. So they could not be preference. The one being the youngest or the oldest, and now he needs to get less. No. All those are handled and decided on own merits. Cost of living, yes. Obviously, in the Beatrice case, the court said that the ever-escalating cost of living should be taken into account. Bearing in mind that the Beatrice case was a 1995 case, there was a Louis case right at the bottom of the screen, which was a 1973 case, where the court held that a substantial increase in the cost of living was not in itself a good enough reason for an upward variation or for an increase. Additional factors had to be present. We tend to disagree, and this came out in the Beatrice case, where the court said that they would take into account the ever-escalating cost of living. Because now we could actually argue that inflation has become a much bigger problem now than it was 15 or 20 years ago. Retrospective variation, could an order be made retrospectively of effect? In the Habs case, the court held that the variation of a maintenance order may be made retrospectively. However, the court said that the power to do so should be very sparingly used. Termination of maintenance orders in respect of minors, the duty of care. Remember now there's a difference between paying maintenance, which is a court order, and the duty of support. The duty of support does not terminate when a person reaches a particular age or even maturity. The duty of care, duty and support will always be there. That's a common law duty that the father needs to support his child regardless of his age. If a child becomes disabled at the age of 40 and he is not self-sufficient, who do you think the duty of care falls on? On the parents. On the parents. The parents still at that age would have a duty of care, a duty of support. If a